Hi, I'm going to be talking about the Maryland inheritance tax. Just as a quick intro, the inheritance tax is not the estate tax. The inheritance tax is a different death tax. The estate taxes apply only to the very wealthy. The inheritance tax applies to um, anybody. Just as an aside, the inheritance tax is illogical, inequitable, unworkable, and unnecessary. But that's a topic for a different day. Right now, we're just worried about how it works. So, the inheritance tax first, it applies to just about any property that's going to transfer at death. So, if it passes by will, intestacy, through a trust, through joint tenancy, um, it's going to affect any transfer that's meant to happen at or after the decedent's death in terms of possession or enjoyment. Anything pay on death, transfer on death, living trust, retirement accounts, life estate deeds. Even if it was transferred in contemplation of death and transferred in the form of a testamentary distribution, then that is also going to be taxed. Also, if it was transferred during their life, but they retained some kind of power over it, um, then that's also going to be taxed. So real quick, real property is going to be subject to the tax if it's in Maryland. If it's outside of Maryland, it's not subject to the Maryland inheritance tax. Um, Intangible personal property, so mostly we're talking about cash or stocks or bonds, is going to be subject to the tax only if the decedent was domiciled in Maryland at the time of their death. Tangible personal property is going to be subject to the tax if it was located in Maryland or if the decedent was domiciled in Maryland. So that's usually going to be like a car. So the tax is 10% of the clear value of the property. So the clear value is going to be the market value minus any debts that are secured to it and the expenses of administrating that property. But there are a ton of exemptions, so very few people actually end up paying this tax. It does not apply if it goes to the decedent's spouse, registered domestic partner, child, stepchild, or former stepchild, spouse of a child, or spouse of a stepchild, or spouse of a former stepchild, surviving spouse who has not remarried of a deceased child, stepchild, or former stepchild, the lineal descendant of a child, stepchild, or former stepchild, the spouse of a lineal descendant of a child, stepchild, or former stepchild, surviving spouse who has not remarried of a deceased lineal descendant of a child, stepchild, or former stepchild, parent, step-parent, or former step-parent, grandparent, sibling, or half-sibling, or certain companies that are owned by those people except for the domestic partner. The inheritance tax is going to be exempt if the property is passing to a government entity or almost all 501c3 nonprofits. The tax does not apply if it's in the form of life insurance paid to a beneficiary, but will apply if it's paid to the estate. Probate assets are exempt if it's a small estate, meaning there's going to be less than 50,000 of probate assets. It doesn't apply to the first $1,000 to any one person. It doesn't apply to the gains or losses on probate assets because those are already subject to income tax. It doesn't apply to the first $500 left in a will for the grave maintenance of others. It doesn't apply to burial lot or crypt not held for investment. It doesn't apply to farmland subject to a perpetual conservation easement that passes to a niece or nephew. It doesn't apply to the primary residence that passes to a domestic partner who is a joint owner of the property, even if that domestic partnership was not registered. So in general, you're going to need to get the properties appraised, but there are a few exceptions. For real property, they can use an appraisal or the fair market value as determined for property tax assessment purposes, or the contract sales price if certain conditions are met and it's sold within 1 year. For vehicles, you can use an appraisal or the blue book value. If you're inheriting it to multiple people, the amount of inheritance that one person is just a fraction of their ownership. And you don't take into account the right of survivorship at all. Um, there's some special treatment for small businesses and farmland, which you can read about. So one very, very, very important point is that the law at the date of death is the law that applies, right? So if you're probating an estate from 50 years ago, then you need to look at what the law was 50 years ago to see what the inheritance tax is owed, um, which makes it very difficult. Um, um, Unpaid inheritance tax can operate as a lien on the property. Um, so let's go over maybe one or two avoidance strategies. One is a little bit obvious, but first, so if there is a non-exempt beneficiary that you want to inherit something from the estate, then you can just leave them life insurance and leave your exempt beneficiaries. Let's say your exempt beneficiaries are your kids. You also want to take care of your nephew. You leave life insurance for the nephew, and you leave the probate assets just to the children. That way, everything's exempt. The life insurance is exempt to the nephew, and all of the property that's going to the kids is exempt. Another strategy is just to change domicile before you die, or have multiple residences so that you can argue that you have changed domicile before you died. One other thing is a third strategy is that um, let's say property is left to a sibling and their spouse, right? Their spouse is not exempt. Only the sibling is exempt. But if it was transferred jointly to the spouse and the spouse can disclaim their interest, and then it only goes to the exempt beneficiary, and then it's tax free. But you got the same result essentially. Um, all right, one last thing. So often, whether or not the familial exemption applies depends on whether a certain parent-child relationship was established, right? Obviously, that's going to be the case if it's passing to a parent or a child, but also whether a sibling relationship exists at all depends on whether they have a common parent-child relationship with the same parent. So it's important to know whether a parent-child relationship exists. So it's going to exist. A child is a natural child, adopted child, child conceived with the parent's DNA after their death if certain requirements are met, born or conceived during marriage or registered domestic partnership. Um, if the child was birthed by that parent, then they're the parent. Judicially determined. The child birthing parent identified the other parent as the biological parent, and that person agreed. Or whether one parent acknowledged themselves in writing to be the parent of the child, um, where the parent has openly and notoriously recognized the child to be their child, where the individual has subsequently married or registered a domestic partnership with the birthing parent and has acknowledged himself or herself orally or in writing to be the parent of the child. There are no equitable doctrines that are recognized to avoid the inheritance tax. Thank you. Have a good day.